Now, there's nothing more likely to bring instant sobriety to a room than a discussion that involves lawyers. So farming is becoming more data-driven, but who really owns that data and what are the legal risks? Our first speaker, Todd Janzen, is an agriculture and technology lawyer based in the US. He's advised farmers, ag tech providers, and industry leaders on the evolving legal landscape of data collection. Today, he'll share how the US is handling these issues and what lessons Australia can take from their approach. Joining us virtually, let's welcome Todd Janzen with Understanding the Legal Issues with Collection of Ag Data, a US Perspective.
Hey, great. Thank you, everyone. Good morning, and I hope you are all enjoying the conference. It's good evening for me. I'm sitting in Indianapolis, Indiana, and here to talk to you about agricultural data and issues with respect to cow data and dairy data from the U.S. perspective. And so I will just jump right in for the time that we have. Let me start by saying that, I grew up on a farm just like a lot of other people. And so my story is one where I decided not to become a farmer after I went to college and instead decided to go to law school instead. And I kind of figured out very early on in my legal career that there were not a whole lot of lawyers who wanted to work with farmers. And so I set out from really the get-go to make agricultural law my thing. And so from the very beginning of my career, I said, I'm going to work with farmers and I'm going to cater to the needs of farmers and agriculture. And so that was great. Worked out very well for me. And somewhere about 10 years ago is when a lot of my career started to shift towards more new technology issues, because what we started to see in the US, and I'm sure Australia was exactly the same, was that there was a real transformation happening on the farmstead. And that transformation was one from analog to digital. And so we were seeing just a wave of new products, and companies want to acquire digital information from farmers to use for their own products. And this ranged everything from, your legacy companies like John Deere or Monsanto to new startups that wanted to go out onto the farm and do data analytics. And so out of that real change, I started to get a lot of work as a lawyer because a lot of these companies wanted to collect data from farmers and wanted to also know how to communicate with farmers about what they were doing. And so as a lawyer in the ag space, I ended up getting a lot of those different types of projects. So let me tell you what I want to talk about today. The first thing is to talk about ownership of data and how that plays out on the farm. Secondly, talk about what traditional contracts might say about agricultural data. And then the last question is to ask you about whether or not you should care about any of this and what the possible ramifications are for getting things wrong. So to start out, what am I talking about when I talk about all this data coming off of the farmstead? There's really all sorts of different buckets you could put it into. These are just a few of the major ones that I've seen. So pharmacological data, machine data coming off machines, genetics of animals, weather data, financial data, performance data, and also I would say agronomic data about how crops are growing. So all of these are potential data streams that come off the farm, and particularly off of the dairy farm, that may be information that the farmer gathers that then companies want to use for various purposes. So from a legal standpoint, I always like to talk about what exactly ownership is. And in common law jurisdictions like the United States and England and I believe Australia as well, We talk about ownership as a bundle of rights. Think of it as like a bundle of sticks in your hand. And if you have ownership of something, you have the right to do various things to whatever that item is. You can use it, enjoy it. You can exclude others from using it or enjoying it. You can transfer it, consume it, destroy it, or possess it, among other things. So that's what we traditionally think of as ownership. And I would say, too, ownership is a legal construct. So it's not something that exists in nature, but something that we've created doctrines and laws to memorialize. And if you think about ownership of data, I think it's good to think about it in the context of how we view ownership now in the law in the United States and elsewhere. For tangible property, things like corn coming out of a combine, a truck, or land, we've created whole systems of rules and laws about how you own those things and how you transfer them. Like a truck, for example, in the US, there's a certificate of title, and you may be the person driving the truck, but if you don't have your name on that certificate of title, you're not the owner of that truck. And so that's a document where we memorialize what ownership is. The same with land records or a lot of other things. Now, when we get to intellectual property, things that are not tangible, things that you can hold or touch, we also recognize property ownership of these items. So the four big ones in the US, and I believe would probably be similar in Australia, copyright, which is protection of literary works or creative works like movies, TV shows, commercials, you name it. Trademarks, which is recognizing ownership of brands and service marks, like the John Deere Leaping Deer is a good example. Patents are recognition of ownership of inventions or new ideas that are new, useful, and not obvious. And then finally, we have trade secrets, which in the US is a recognition of ownership of something that is like a formula or recipe or a process that a company knows or a person knows, but they don't share it outside of their own walls. And so it's kept secret. And we do recognize ownership of that. So, that all begs the question, where does data fit in, these streams of data that come off of a farm? And if you think about it, in many ways, a lot of those bundles of rights you can apply to data. You could exclude others from using it. You could transfer it, right? You can license it. You could destroy it. So a lot of these rights would apply to data. But the big difference, I would say, with respect to data is that it's infinitely replicable. And so even though I may have these rights in data, I can transfer that data to you, and you can have all the same rights in the data that I have. And so that makes data very different than other forms of property. And I would say also, in the US, we have laws that reference ownership of things like copyrights and patents. But when it comes to data, it's a little bit more open-ended, and it's not quite so clear always. I think for purposes of time, I'm not going to spend too much time talking about these two items, but when we think about data ownership, at least in the US, we have had some cases where they've dug into this question a little bit more. And for example, we had a case back in the days when phone books still existed, where someone copied a phone book and then republished it. And the company that originally published it said, no, that's our information. You can't copy it. And our courts said, well, there's nothing unique or original about phone numbers in a phone book, so that is not data that we are going to protect as a matter of law. A similar thing happened with LinkedIn. There are all sorts of programs out there that scrape data off of LinkedIn. And our courts have at least so far said that that's not data that LinkedIn owns, but it's instead data that is available to the public. And so therefore, LinkedIn can't exclude others from using it. So the moral to the story here is, who owns this data that comes off of the farm? What the answer would be, I'd say in the United States, is it matters what your contract says. So ultimately, whoever has the contract with a company that's collecting data, that's going to establish all of your ownership rights in that data from both the farmer and the company standpoint. And that assumes that companies get it right and explain it in a clear and easy to understand manner, which is not always the case. So what I want to do next is look at a common version of a contract. I pulled this one out of the dairy industry. I did change the names to protect the innocent, so it doesn't identify where I got it, but it is a software product that is very commonly used in the U.S. on dairy farms to talk about data coming off of those farms. So there's a lot of words on the screen here. I will not read this to you, but for this particular contract, I'll call it Data Co. as a generic term for the company. The dairy farmer here does have a provision in the contract that explains data ownership. And so that's a good thing. It's a good thing that the company is trying to explain what its position is on data ownership. So let's zoom in a little bit and see what it says. It first begins by talking about, I'd say, a promise, which is that the customer is the owner of the data gathered by the customer that's inputted into the licensed software. So there's first a recognition that the farmer here would be the original owner of the data. As you go through this paragraph, then, the next portion of the paragraph explains that the customer here owns all the right, title, and interest in the data. So again, I promise that we're recognizing that the farmer owns the data here. But then it goes a step further and says, if we're going to recognize your ownership of that data, then you need to make best efforts to ensure that raw data is true, accurate, and complete. And so what the company who is using the data here wants to make sure of is that the farmer isn't feeding it, bad data that may mess up its algorithms or maybe for some other nefarious purpose. So that's the promise that is good here, I would say, in that it promises that the farmer does own the data. But now when you shift gears to the next paragraph, this is where a lot of the rights are transferred to the company that is going to license that data. So then it goes on to say that the customer is granting DataCo a license in the data that is, there's a whole list of licenses here: worldwide, irrevocable, unconditional, royalty-free, perpetual, and it gives the company the right to upload and store that data on its own servers. Now, if you go further into this paragraph, it also then says that the company has the right to copy, modify, use, distribute, prepare derivative works, perform, display, otherwise exploit the raw data. So the first paragraph really recognizes a lot of rights in this data to the farmer. The second paragraph licenses all that data to the company and really, I would say, essentially gives that company full rights to use that data from the farmer for however it sees fit, including to exploit it, which would be to perhaps commercialize the data, use it in some way that helps make the company money that may have no benefit to the farmer whatsoever. So, that's a typical licensing provision you may see in these contracts. And so, that begs the next question that I want to talk about, which is, should this matter to anyone? And, should the farmer worry about a blanket license like this that gives a company rights to use the data for virtually any purpose, including to exploit the data for its own purposes? Well, I think one question I'm often asked is, well, wouldn't there be some law out there that would protect the farmer's interests if the company did something with the data that they had licensed in a nefarious purpose or in some way that was detrimental to the farmer? And so if you look at this from the U.S. standpoint, when we've had discussions and passed laws about data ownership and privacy in the U.S., there isn't really a national law that protects personal information. So things that address, sharing name, address, social security numbers, phone numbers, things that people might not want out in the public. There's not a national law. Instead, what we have is a series of state laws that all address this differently from state to state. And so we have decided in the U.S. that that's the way that we want to do it, for better or worse. But these laws do protect personally identifiable information. They would not necessarily protect data coming off of a farm, only to the extent that it references the farmer's name, the farmer who owns it. We've also seen a number of state legislators introduce laws to try and protect data privacy, not just of personal information, but on a more of a data privacy standpoint, where data may not be tied to personal information. Now, I would say I've not read every bill out there or law, but in general, these don't touch on agricultural data because they're really not designed to protect farmers. They're designed to protect consumers and consumer data, and not so much for farmers. Also in the U.S., there are a few instances where the federal government has decided that we want to protect data rights. And so these are the examples. HIPAA, which is our national law that protects medical information for humans. So if you go to the doctor, that doctor's office cannot share your medical information with anyone else unless you give them permission. Financial information, banks, and lending institutions also have rules about how much personal and financial data they are allowed to share. And then personally identifiable information that I already talked about. And so the question is, would any of these apply to dairy data and potentially financial laws that protect financial information would, to the extent they involve, financial information from the farm. But for the most part, I would say, no, the laws do not address misappropriation of data. And so those contract terms really do matter. Another thing I wanted to mention, in the U.S., the agricultural industry itself has taken it upon itself to try and put some guardrails around collection of data from farmers by creating a ag data transparent certification. And so this is a national and somewhat international effort to do a certification for companies who want to provide more transparency about how they're collecting data from farmers. And so it's essentially an 11-step certification where companies have to answer questions about, how they are transparent with data, what their position on data ownership for agricultural data is, And then other things as well. I have some here on the screen. For example, portability. Once data is acquired by that company, can a farmer get it back and then transfer it to another company? Can a farmer ask that the company erase the data from the farmer if they decide to stop using the platform, or is it there forever? These sort of questions are answered through an Ag Data Transparent certification. And so I'm actually the lawyer who reviews those certification forms, so I'm pretty intimately familiar with how the process works. Today, we've had over 40 different companies go through the certification, and they vary quite a bit. Some of these names may not be familiar to you, but I'll just say in general, we've had companies like John Deere do the certification, and then other companies on the list. Some would be large farm cooperatives. Some would be seed companies. Some are farm financial management companies. And then a couple that are also even in the livestock sector, such as Ag Sites, which is a livestock data management company, and Everag as well, which has a product called My Dairy Dashboard. So there are even companies in the livestock space that have been through this certification. There's still a lot of work to do here, though. I would say that maybe half of the industry players have gone through the certification, and they do have to re-up it every year. So just doing it once isn't enough. They have to recertify year after year. But it is good to see that companies have taken it seriously, and we have quite a few that really want to play nice, play by the rules, and treat farmers with the respect that I think farmers expect. So let me ask this question. It's a rhetorical question, but there are definitely some answers. Perhaps you think it doesn't matter, right? So what if a company has all the rights to my cow data, everything from my farm? What does that really matter in the end? And so I'll ask farmers and say, okay, I understand that. So let's think of some possible ways that data might be used that you would not necessarily anticipate. Is it okay if the company were to commercialize that data and make their own profit from it, even if there's no benefit to you? Would it be okay if the company that licensed your data turned it over to a regulatory agency, for some purpose? Would it be okay if that company gains a competitive advantage? So perhaps we see this on the grain side, that there's worry that a company that collects data from grain farmers may have more information about yields and how crops are doing in the country than farmers would. So now there's a competitive advantage to the company that's collected all this information that their own farmers who are contributing the data don't really have. Would it be okay to use the data to improve sustainability and conservation? And then finally, I'd say, is it okay if companies use that data to improve services that they want to offer back to the farmer, even if it means maybe they sell those services for more money because they know how valuable they are? So there are a lot of ways that companies can use data, and they're not always the same ways that farmers may anticipate. We had a great example of this a couple of years ago where a number of rural landlords who rented land to farmers, got letters from a company that was saying that the rent they were charging their farmers was too low, and they could actually get more money if they would, rent to the people who were in this digital platform instead of the local farmer they were used to. And they would show them, comparable lease rates across the country. And farmers really went pretty crazy when these letters went out and started to worry that perhaps data that they had been giving to some of these companies had been used by this company that was now trying to build a business off of charging more rent for land that these same farmers were using. So it played out over a series of time, and ultimately the company went out of business that was trying to do this. So it didn't work in the end, but it certainly gave farmers a lot of pause. So here are your takeaways from my talk today or this morning. And these would all apply in the US and perhaps in Australia as well. But in the US, the contracts will determine ultimately ownership rights in data because no law specifically addresses these points. The second point I would make is that the contract may not always say what people think it says. And dovetailing into that, US data protections are not designed for dairy data, and so they're not going to protect dairy data. So it all goes back again to those contracts and what those contracts say, and that's going to be the determining factor about how all these issues are resolved. So, we like to think that the contracts in the digital sense don't matter so much. People just check a box and go on with their lives and don't think about it. But at the end of the day, those contracts really do matter, and they do make a big difference, and they could make a quite enormous difference to a farmer whose livelihood is at stake based upon all this data and who has control and ownership of it. So that concludes my presentation. I will stick around for a few minutes if there are questions about the content that I covered, and I'm happy to answer those. And if there aren't any, then I will be on my way home for dinner, and you all can enjoy the rest of your conference.
Great. Thank you so much, Todd. Todd, that was amazing. I think you've taken what can sometimes be a bit of a dense but very important topic and make it really clear and understandable for us in the room, even those of us who have stayed up late and maybe a little bit hungover. So thank you so much. We do have time for questions. We have one that's come through online to start off with. So from Jack Holden, we have, what happens if the contracts make no mention of data ownership?
Oh boy. Well, I think then you're living in a gray area, and I'm not sure what the answer would be there. There's not necessarily a default. I would certainly argue that the farmer should be considered the owner of that data since it originates on their farm, but I think it's certainly not. It's not going to be clear at all in that sort of instance who's got ownership rights, and so. Ultimately, how that could play out would be if there's some dispute about later on about a product and who owns what and what rights someone has in it. You'll have to leave that to litigation to sort out. One side note here, I would say with AI platforms, we're starting to see this now because artificial intelligence platforms require just an enormous amount of training data to make them effective. And so sometimes companies don't license the data to train their AI models like they should. And so what that means is suddenly now you have people who say, well, I have an ownership interest in, in the AI model in that AI platform because my data was used without my permission to train that platform. And a great example of this was Scarlett Johansson, I think had sued or had talked about suing one of the AI programs that used a voice that sounded exactly like hers. They said, no, this was not something that they misappropriated. She said, well, she disagreed. But that's an instance where, the ownership of that underlying data isn't clear. And so now they're going to have to sort it out.
Yeah, that is very interesting. I think we're in a room full of people who are geneticists and scientists and herd improvement organisations, so we are data nerds and we love data. But it isn't always clear, like, who owns the data? Is it the farmer whose farm generates that data, who owns the cows? Is it the people who go out and take the effort to collect that data? Or is it the people who pipe that data and store it? Or is it the people at the other end using it? It's never quite clear. Do we have any other questions from the room at this point? So I have a question then. When there isn't clarity in the contracts, Todd, as I think Jack Holden mentioned, and there has been a dispute or litigation about this, does there tend to be a sort of leaning from the courts as to who does end up being the default owner, who has more rights in that space? Or is it very much a case-by-case basis?
Yeah, I think it's probably a case-by-case basis at this point. There's usually going to be some form of contract that addresses, maybe not ownership, but does address that transfer of data from the farmer or the consumer, whoever it is, to the company. And so I would say it's rare that a court would be working with zero language at all. There's going to be something that they can construe one way or the other. And, ultimately, if they have to pick a side, they will. But I don't know that you could say there's a default one way or the other.
Okay, thanks. That's very sobering. Do we have any other questions from the floor? All right, wonderful. We'll let you get back to your dinner then, Todd. Thank you so much for joining us in Australia.
Oh, my pleasure.